The Nigerian justice system and the last hope of common man died today at Federal High Court, Enugu, as Justice Liman delivers what could be record-breaking, the worst judgment in the history of world's legal system. The case was filed by Alaigbo Development Foundation ADF against Nigerian President Mohamed Buhari, challenging his unlawful deployment of troops to southeastern Nigeria under the code name Python Dance, Egwu Eke 2. The Python Dance resulted to physical torture, loss of lives and properties, which generally violated human rights of affected victims of the operation, and by extension, the entire Alaigbo in Nigeria. BVI Channel 1 was in court to get detailed information on what transpired in court today. Hello, this is BVI Channel 1. I'm also Chinedu Peters. I am reporting from Federal High Court, Enugu. Today, the ADF, Alaigbo Development Foundation, got a judgment finally. And the judgment was, I would say it is totally unacceptable to ADF, owing to the fact that the judge became the counsel for the defendant. And to the widest imagination of anyone who have followed any judicial process, this is height of judicial rascality. Hello, sirs. Can I meet you, please?
My name is Max Azaka. I'm a legal practitioner. I'm the lead counsel for the Alaigbo Development Foundation in the judgment that the court just delivered.
Okay. What can you make of the judgment today?
Well, in the first place, I must say that I am disappointed in the position that the court took. To start with, the defendants did not put up appearance in this case. They didn't file any defense. They didn't file any paper. And that, first of all, says that our averments in our affidavit were not contradicted in any way and should be deemed as proven by the court. And unfortunately, the court turned around to now believe contrary to what we have averred in our affidavits. This is strange in law. So I'm surprised that the court should give the kind of judgment it just gave.
All right, so how are you taking it from there?
The point I'd like to emphasize is that the court, which I find that's what I find strange, because we deposed in our affidavit that, contrary to what the army said in their publication, or rather in their what's it called, communique or whatever, or press conference, we said that the entire Southeast was at that particular point in time in a state of calmness and tranquility. There was nothing that called or necessitated the deployment of soldiers to the Southeast. But the court took a contrary factual view. There was no fact to the contrary before the court. But the court believed and stated that there was a state of anarchy in the Southeast and justified the Operation Python Dance. That's what I find strange.
Okay. Hello, sir. From your own angle, will you say that that you got the justice you deserve, or are you expecting to take it further?
We are certainly going to take it further. We didn't get justice here today. That's quite clear. We cited 3 precedents. The case of Yusuf versus Obasanjo, and ironically, the case of Buhari versus Obasanjo. Buhari had, when he was a presidential candidate, when he had not even won the election, and when Obasanjo was president, he had sued then President Obasanjo based on the theory of section 217 and 218 of the Constitution, which were the 2 sections are in play today. And Buhari won. He won, arguing on the same plank, on the same theories, on the same logic that was thrown out by this federal court today. The same Buhari deployed soldiers that he had argued and sued against when Obasanjo was president. So the court today did not cite any superior case, any case from the Supreme Court or Court of Appeal to contradict these 2 judgments. Rather, the court veered off to questions of interpretation of the Constitution, of which, if you apply those questions straightly, we would have won the day today. And the application is in application of the interpretation of the Constitution, which the court did today. He moved the word "may" in section 217 to front of subject. The word subject came before the word may. It says subject to an act of national that may be that's subject to an act of National Assembly or conditions that may be prescribed by an act of the National Assembly. So it shall always be subject. So it is now up to the National Assembly to prescribe those conditions. So the word may applies to how the National Assembly chooses to prescribe the conditions, the limitations, and the narrowness of the military intervention. Not that the National Assembly can willy-nilly go to sleep, that it may go to sleep while the president runs riot, deploying soldiers to police duties and breaching Section 215, which gave police duties of this country to the Nigerian police force, which is standing there. So these issues were not addressed by the court at all. And just as my senior colleague here had said before, this is a case that throughout its pendency in this court went unchallenged. What happened to the 4 judgments? It's a common law system. Everybody knows it. Even a layman knows it. If you don't put up a defense, it's held against you by any common law country. This is not just a court of law, it's also a court of equity. The federal government, thumped its nose against this court, and the court should have taken notice of that. And at least, if he wanted to do federal government a favor, or maybe do what he did today, he should have just rendered a default judgment, not with prejudice, but this is a default judgment for failure to appear, for failure to to contradict the quantum evidence we submitted on behalf of Alaigbo Development Foundation. He should have just said this is a default judgment and give the federal government, force the federal government to come before the court to defend what it did. Thank you.
Hello, sir. Can I meet you, please?
Well, I'm Dr. Jerry Chukwokolo, the Financial Secretary of Alaigbo Development Foundation.
Okay, you are here today in court to witness the judgment of your organization, who filed a case against the federal government regarding Operation Python Dance, the constitutionality and the legality of that action. So what can you make of today's judgment?
I will simply say that this is outrageous, an outrage. And this is also judicial rascality. Because first of all, what it is instituting is that somebody, you can take a case to the court against the federal government, and the court will ratify that the federal government has right not to appear in court, and the court will take the role of the counsel of the federal government. And that is what the judge has done today. Secondly, I think that we have been looking at the way things are. A judgment that relies on Punch newspaper, that is not pleaded by the plaintiff's counsel, and the judge uses it to establish his case, is to the least annoying. According to them, the judge who is here in Enugu, who was here in Enugu when that matter was going on, has come to say that what the army wrote was that there was a case of anarchy, insurrection, and assassination, kidnapping, everything, all these heinous crimes. And the one they are doing in some other places in the north, even the herdsmen killings in Benue State, it is nothing. That is what the army taking the decision, such fatal decisions they have taken. I think that as far as I'm concerned, 2 things came into my mind. One, we must decide whether we have to continue to be in such a country where one ethnic group, the Fulani, will be in charge of all of the judiciary, and then they decide things the way they like. I am not trying to do some things, make my judgment, but the way the judge was reading the matter, as far as I'm concerned, shows me that maybe it's possible he did not write the judgment. Because if I had written anything, I would know what I have written, and I'll be reading the thing fluently. So, but the way he was reading it calls to mind the question of the possibility of people staying outside to write the judgment of the court. It is not acceptable that somebody will just come from another tribe and stay in a place and give judgments that does not reflect the problems and challenges of the people he is living in their place. I did not see where that law where he has read. In fact, I can say that this is political judgment that he has given. And of course, that was why the president, when he came, he decided to deal with the judges so that people will be afraid of him and be doing things he wants to do. But we cannot continue to look at things this way, because if we continue to look at things this way, Nigeria will go to the precipice. And as far as I'm concerned, we have all the indices of a failed state, and that's exactly what we have seen. We cannot continue to look around. Of course, we have given the lawyers the instructions to challenge the court in the appeal. The judgment in the appeal court. This is travesty of judgment. Justice. We came here for justice, and we will not allow such a travesty to be upheld. This is exactly what we are saying, and it is very, very amazing that a judge in this matter, the federal government, the president, the army, and the chief of army, they were duly served, and they never appeared. The judge took the position of the president counsel, and he went on to give such a judgment. I never expected anything contrary to this. If I had asked my people, they would tell. I told them, I can't expect anything more than this, because I've seen the level of rascality and arrogance. A judge who will come to court after 3 hours that is supposed to come and will not apologize to the court for coming late is in the least arrogant and a rascal behavior to somebody who is a public servant, public office holder. So it is amazing, and we cannot continue like this as Nigerians.
Hello, sir. I assume I already know you. Most of our audience have already known you. The time we come the other time for the judgment, and it failed. Or today you had a judgment. What can you make of today's judgment?
Well, I'm advised by our lawyers that the judgment was a very curious one. In the first place, I think they were expecting that the judgment would have been given against the federal government for non-appearance. And it appeared that the judge became the lawyer for the federal government. It appears it's a premeditated judgment. And I think we have instructed the lawyers to appeal against the judgment.
Hello, sir. Can we meet you, please?
Yeah, Eric Uche, member of ADF, Alaigbo Development Foundation.
What's your reaction with the judgment you got today?
Well, my reaction, I wasn't really surprised, because I was here the last time this case was on, and the way the judge himself was acting as a defendant and, trying to play the role of being the attorney for the federal government was really, he's supposed to be a judge and not, an attorney for the government. It's embarrassing, where you find a judge who is supposed to be neutral is not neutral. The ruling today simply undermines democracy in every sense of it. So if we're not running a democracy, what's the point of, citing the Constitution every now and then? We should really either go back to citing decrees, and know where we stand, basically. So it's pure mockery of this poor nation. It's pure mockery of the African continent, and it's pure mockery of the black man. If foreigners are watching this and seeing the way things are going here, they'll still be looking at us as monkeys. Funny enough, not long ago they told us monkeys swallowed some millions of naira. Not long ago it was snake swallowing. So we're back to the zoo.
We are here to report the things the way they are, and moving further, they are going to apply for or file a case for appeal or whatever, and expect judgment from the upper court, or peradventure take it to the international court. You sit back, stay glued to BVI Channel 1. Will continue to enlighten you, and we continue to inform you the right way. I am Asu Chinedu Peters. I am reporting for BVI Channel 1, Enugu, Biafran land.